Hello, everybody, and welcome to this special webinar of the School of Transnational Governance to discuss the recent decision by the German Constitutional Court that is likely to have a very strong impact on European integration, both with respect to the euro area and its currency and to the policy in particular of the European Central Bank, but also with respect to the fundamental legal architecture of the European Union, in particular the principle of primacy and the exclusive jurisdiction of the European Court of Justice to decide on the validity of EU acts. I have with me four great speakers and experts from law, political science, and economics. I have Franz professor of constitutional law in Germany, Deirdre Curtin, that is a professor of European law at European University Institute, Christine Landfried, well-known expert of political science and particularly of the role of constitutional courts, and Jean-Pierre Ferry, one of the most well-known European economists and also part-time professor at the European University Institute, the Robert Thomas Center, and Sciences Po in Paris. Thank you all, the four of you. I'm going to give the floor first to Franz, but Franz asked me also to set up just a little bit for those of you that are listening that may not be totally familiar with this decision, though I think that if you are tuning in to listen to this, you probably are, some of the basic aspects of this decision of the German Constitutional Court. This was not the first time that the German Constitutional Court had threatened the supremacy and the primacy of EU law, and that threatened to assess whether or not an act of the European Union institutions and of the European Court of Justice were ultra vires, that is, went beyond the competences that the treaties give to the European Union institutions. But it was the first time that the German Constitutional Court walked the talk. That is, the German Constitutional Court either actually transform that threat, the idea that even if it will recognize in general the primacy of European Union law, it will reserve for itself the possibility in extreme cases to declare an act of the European Union as ultra vires. This was the first time the German Constitutional Court actually did so. It did so perhaps not in the best of cases to do it, but that's something that our guests will discuss. But it did so with respect to a series of decisions and a policy of the European Central Bank, the policy of the European Central Bank that was at the core of the whatever it takes approach set up by the former president of the European Central Bank, Mario Draghi, and that basically led to our acquisition in the market by the European Central Bank of public debt, of public assets. The German Constitutional Court decided that on basically on the grounds that the decision of the ECB was not proportional. There is an interesting aspect that the first and primary challenge was actually that such a policy of the ECB would indirectly violate the principle of the no bailout clause, that is, of the prohibition of monetary financing, that is in Article 123 of the Treaty on the Functioning of the European Union. But with respect to that fundamental challenge, the German Constitutional Court actually considered that there was not a violation of Article 123 because the policy of the ECB as set up in those decisions involved a series of guarantees that maintain a certain degree of market discipline over the budgetary and fiscal policy of the member states. That was so notably because, according to the German Constitutional Court, in that respect, agreeing with the European Court of Justice, the policy of the ECB had a limit that was basically 1/3 of what it could buy from each member state, that the allocation key was corresponding to the position of the different member states in the European Central Bank system. And therefore, there was a series of guarantees that, in view of the German Constitutional Court, made so that the measure could not be certain to have violated Article 123. Nevertheless, and this is another interesting aspect that I'm sure you're going to discuss, if the previous policy of the ECB did not, in fact, did comply with that set of conditions that are presented as necessary by the German Constitutional Court, the new temporary emergency regime for the pandemic that the ECB has announced now by Christine Lagarde no longer respects or no longer has that similar set of conditions. And so even if the German Constitutional Court decision, as the court itself explicitly states, does not relate or is not directed, does not have as an object the recent new program set up by the ECB, one could deduce from the obiter dicta, from the reasoning of the court, that in fact this new regime will be even from taking into account the reasoning of the German Constitutional Court, will be even more more clearly in violation of the EU treaty. So it raises a doubt, it raises a shadow, it raises uncertainty as to the new policy too. But in fact, with respect to the previous policy of the ECB, what the German Constitutional Court considered was that the measure was in violation of proportionality, because it did not take into account a series of economic effects, or at least that the ECB had not demonstrated that it had taken into account a series of economic effects. In fact, the decision does not seem to be very clear if it is charging the ECB with a violation of the duty to motivate its decisions, or with an actual violation of the principle of proportionality. It seems in part to actually say that what is lacking is the justification making clear that the measure is proportional. And with respect to proportionality, is also not clear if the problem is whether the not taking into account those economic effects violates the fact that the measure ought to be primarily a monetary policy measure. And therefore, if what the court is concerned is with ascertaining if the center of gravity of the measure is monetary policy or economic policy, or if instead it is a problem of balancing the economic benefit, the monetary benefits that the measure might generate with the economic negative impacts that it may have. Nothing of this is very clear in the decision, but the decision is bound to have very important effects for the ECB policy, and more in general, for the primacy of EU law, because it is the first time, at least at the German Constitutional Court, basically clearly states that it is not complying with the judgment of the European Court of Justice, and that moreover, that German public authorities, the government, the Bundesbank, ought not to comply with the judgment of the European Court of Justice and with the decision of the ECB. And this, therefore, creates a precedent that may endanger the primacy of EU law, and that may be followed by other constitutional courts. Very briefly, these are some of the issues that the decision set up. And now I will give the floor first to Franz Meyer. Franz, you are a very well-known expert on the case law of the German Constitutional Court. You've pleaded some of the previous cases where the German Constitutional Court addressed the relationship between German constitutional law and European Union law. You were the agent of the German federal government in some of these cases. So can you provide us not only your view on what this decision means, but a little bit the context that surrounds this decision?
Well, thank you, Miguel, for introducing me. Thank you for inviting me to this round. I really think it's important to talk about this case. This is a case, and you said it in your introduction, that has many, many aspects. It's about the question on whether this is monetary policy or economic policy. In a way, it's also the epic battle between the German Constitutional Court and the European Court of Justice. It's also about, are you for or against the euro, the monetary union, and at least on the side of the plaintiffs of the case, you also have the very basic pro-EU, anti-EU antagonism. I'd like to start out with a quote from the German Constitutional Court, which is actually a quote from a dissenting opinion of a couple of years ago. And the quote goes like this. I'm reading here from the official English translation. in an effort to secure the rule of law, a court may happen to exceed judicial competence. In my view, this has occurred here, end of quote. And this is a quote from the dissenting opinion of Judge Gertrude Lübbe-Wolf's dissenting opinion in the OMT case in 2014, the very first preliminary reference to the ECJ. She was dissenting, and she basically said at the time that she saw an ultra-virus act on the side of the German Constitutional Court. And I believe that 6 years later now, we can completely apply this sentence to PSPP. We have a wrong decision here. We have an ultra-virus act in Karlsruhe, at least on 4 counts. It's a wrong decision on from the perspective of EU law. It's a wrong decision from the perspective of German constitutional law. It's a wrong decision from the perspective of European policy and politics, so the German perspective, and even from the perspective of constitutional policy in Germany. Now, the first aspect is pretty easy. EU law has been violated. It's pretty clear that 267 preliminary reference decisions must be obeyed. There's also the question whether the wording of the decision, which calls upon the German government and German parliament to do something, isn't already infringing the independence of the EU Central Bank, which is laid down in Article 130 of the Treaty on the Functioning of the European Union. Actually also in the German Constitution, Article 88. I believe that this is pretty obvious, and that's why I'm really in favor of starting a treaty infringement procedure. The biggest member state must not get away with this. It's another question whether the treaty infringement procedure will go to its very final, brutal end, where you impose some kind of fines or so. After all, we're dealing here with judiciary and independence of the courts, etc. But from a starting point, from at first glance, this is pretty much infringing EU law. But also on, from the perspective of constitutional law, from German constitutional law, you can make the case that they don't really follow their own criteria. After all, we have established case law here. The ultra-virus control, as they call it, has been developed starting with the Maastricht Treaty decision in 1993. Then they came back to this in the Lisbon case in 2009. And after a lot of critical reaction to the Lisbon case, they kind of tuned down their approach in 2010 in the Honeywell decision. And that's actually the law as it stands. The Honeywell decision established a couple of criteria for the German Constitutional Court in order to consider an European act ultra vires beyond the powers of the EU. And there you have things like a structural shift away from the member states towards the EU. There's something about, the ECJ is entitled to be wrong once or twice. They call it the error tolerance. So it's pretty clear that the Honeywell standard is quite generous, and they just don't respect their own standard here. And it's quite funny to read in newspaper interviews of the judge rapporteur after the decision that they explain the harsh language of the decision. And if you look at the decision, it's really brutal. They say the ECJ acted in an arbitrary manner, and it's just, it's methodologically not conceivable what they did. I mean, come on, 15 judges in the ECJ, the Grand Chamber, it's pretty unlikely that they were not knowing what they were doing. And there's also the point that the doctrinal reaction to the ECJ case, it occurred to nobody that this was arbitrary. And so the judge was questioned on that in the interview, and he said, well, we had to call it like that because otherwise we wouldn't have met the Honeywell criteria. And that's quite telling, isn't it? Because you seem to be bending reality in order to fit your criteria instead of asking whether actually reality, the test applies to this reality. So this is already a hint that there's something bigger going on here. But all I'm saying is already from the perspective of constitutional law, you could argue that they don't follow their own yardstick, their own criteria. And there's also something about the way they deal with proportionality, which from a German public lawyer's perspective is pretty odd. I can get into more detail if this is something the audience is interested in. Now, in terms of European policy and European politics, it's catastrophic for Germany because it makes Germany look like the big, 500-pound gorilla in the room that is selfishly looking for its own interests. And I believe there's this kind of suspicion against Germany that, at least in the context of the Eurozone policies, they are pretty selfish and ignorant of the concerns of other member states. And as well on the technical level, the way they discuss and argue proportionality and the aspects they put into their proportionality test, as in the general approach, this is just a really quite German decision, pretty inward looking, and this is obviously catastrophic for the standing of the Federal Republic in the European Union. And then finally, in terms of constitutional policy, the German constitution is pretty open for European integration. It's the preamble that talks about a unified Europe as some kind of, ultimate aim of the Federal Republic, and it's also in the operative part of the constitution. And what they are doing here, and especially the way they are linking their argument to the core element of democracy, which is inalienable in the constitution, which you can't kind of modify by a supermajority in the German constitution, puts basically a couple of options of this open constitution out of reach of the further development of European integration. And that's probably in perspective, that's the really sad and problematic aspect of this decision. And in a way, it's also not very democratic. I don't think that the German Constitutional Court has the legitimacy to decide upon, it's not even the court, it's the Second Senate, and it's 7 out of 8 judges. So it's a majority of the court. And there's something to be said about this majority, actually. I can elaborate on that further if requested. But so a couple of people are kind of more or less limiting the options of the German polity to find their way in the European integration, to go forward in European integration, although the constitution, the text of the constitution specifically requests us to pursue that aim. So that is really odd. Now, on what to do, I understand that will be the second round. There's a couple of options out there. All I want to say here is that it's quite difficult because we don't really know what we should look at. You have the dispositive part of the judgment, which is pretty slim. That's the part after the eagle, this in the name of the people. And there, for example, the Bundesbank doesn't even figure. And if you look at that, and that's actually the only kind of, the solid legal part that could also be executed in a way. So that's pretty slim. Then you have this huge, amount of recitals and explanations in the style of the German Constitutional Court explaining the world. And there you have a couple of things which are really hard to meet, like request for an ECB decision to be taken. And then you have the interviews of the judge rapporteur and of the former president of the court. And that again is totally different because it's kind of just saying, well, we wanted to give a general, it's just a message toward the ECB. We'd like to be the ECB to be more transparent in order to have, some more accountability. And now, what are we supposed to implement? The dispositive part, recital 235, or the interviews?
Thank you, Franz. We're going to get back to some of those issues and how to interpret and how to act based on this challenge brought by the German Constitutional Court in the second round of questions. Deirdre, the floor is yours now, maybe to provide the European side of the story. How does this decision fits both the traditional relationship between the European Court of Justice and national constitutional courts and the reaction that one can expect from the European Union?
Okay, thanks, Miguel, and thanks also to Franz because he's highlighted a number of issues already. I think the only point where I probably disagree with you is on the need for an infringement procedure, but I think we can talk about that at the next stage. I think that needs very careful consideration, and I agree with you that it's the very last part of the judgment that is interesting also in that respect, legally. Well, I think the first point I would make, and what strikes one in reading it, is how the tone of the judgment is in a way quite extraordinary in the way it talks about another Supreme Court in Europe. It almost sounds angry. It's certainly self-righteous. The language used, as Franz already indicated, is extremely strong. It says that, you know, the court's reasoning is not comprehensible. It's arbitrary from an objective perspective, and it's not tenable from a methodological perspective. Now, these are very far-reaching and strong words. You know, the court in Luxembourg has grossly violated methods of legal interpretation by not applying the proportionality principle properly. And given that failure, that was the reason why it could sort of step into the breach, as it were. So that's quite extraordinary in itself. But I would like to talk about the principle of proportionality, because that takes up, in a sense, the lion's share, or the vast, you know, the most of the judgment, and it's actually mentioned 67 times throughout the judgment, which is extraordinary. So this is about, as you already mentioned, Miguel, the balancing of the element of, you know, the fear that monetary policy, price stability was in fact disguised economic policy, and that there was a failure to balance. But I think you can ask serious questions in that regard as to whether proportionality even applies to the PSPP by the ECB. You can argue that, you know, Article 5.4 imposes a much narrower criteria, that acts shouldn't exceed what is necessary to achieve the objectives of the treaty. The ECB, as we know, doesn't adopt legislative acts. Decisions of the ECB are not legislative. And their mandate, they don't have a dual mandate, they have a single mandate. So, you know, that is simply the law, if you like, what is in the treaty and elsewhere. It also concerns an exclusive competence and not a shared competence. And in those, it's normally the lawmaker that would do the balancing, not a judge. Now, of course, the German court could kind of step in, as it were, because the court in Luxembourg has not always been consistent in the way it applies proportionality. It generally applies a pure necessity test. Occasionally, it looks to the effectiveness of measures in that regard, and sporadically, but far less than the other two, it will look to what is called also in the German case proportionality stricto sensu, which involves that balancing. In my view, the court seemed to indicate at one stage that there was a common constitutional tradition, almost a more general one, to do that kind of scrutiny. But I think the reality was, in fact, that they were looking at EU law through the prism of a German law, and lecturing, in fact, the European Court of Justice about the law that should be applied to them. So, so this muddling, if you like, of EU law and German law is highly problematic. Also, proportionality in the manner in which it's applied by the Court of Justice, it does so often as an administrative court and not as a court, as a constitutional court all the time. It also applies it in different contexts. Now, the German court is also very critical of the patterns of reasoning, you know, the way that the court does its judgments, which are, of course, very different to how the German court does. I mean, we know that the court's judgments are very terse. It's not only that there are no dissenting opinions, but they have a certain way, they have elaborate description of the facts and the arguments in the case, because also they're talking to a different audience. They don't hear experts in the way that the German courts do. They don't rely on legal scholars, so they have a different, much, you know, more condensed way in terms of the style of drafting. But that doesn't make it illegal or ultra-virus or any of the strong language that has been used by the court. So maybe just one other point at this point is on the primacy point, because that's obviously one of the core things. Now, this isn't the first time that there has been a challenge, of course, from, you know, there is contestation from higher courts over time in different periods by different courts, but by the highest national constitutional or Supreme Court. And the cases that are most frequently cited nowadays are the Czech, fairly recent Czech cases and Danish cases. But actually, both of those cases, the Czech case and the Danish case, concern the violation by national statutes of EU law and international treaties, whereas here, in the Weiss case, the German court was ruling on the validity of an EU act. So the reference was on the validity and in a field of exclusive competence. So you can say in a way that makes it, it makes it much more alarming, if you like. The judgment can't be enforced through statutory law. I mean, that's also the consequence. I mean, if it's a national statutory law that is breaching EU law, you can amend it. That's not the case here. So in a sense, that is why it also strikes at the very heart of the ECJ's role as being the ultimate and final interpreter of EU law, and that's what's under challenge here. And it's essentially, you know, trying to put the reasoning of the German court before that of the Court of Justice. So, you know, and then the question is, well, to who is this judgment directed? Indeed, the German government, etc. And that I think we need to look into, because I think actually that's one of the most interesting aspects of this judgment. But you know, and I think the other fear, of course, which hasn't been mentioned yet, is the sort of boomerang effect on the illiberal democracies. But you can distinguish the two cases also about what is going on there and the kinds of attacks that are on and this case. And I believe now, even that the Hungarians have pulled back from a full-scale confrontation in that regard, that they've actually accepted to. So maybe that will come up in the second part of the judgment. I don't want to go over time on that, so I'll just leave it at that for now. Thank you.
Okay, Deirdre, thank you very much. You raised a series of points that I think on which it will be interesting to get Christina's view too. Christina, I will ask you to think a little bit and tell us a little bit about the politics surrounding this case, including the judicial politics. So not only the politics in Germany, but the politics between the German Constitutional Court and the European Court of Justice. Franz hinted that in his view, the decision seems a little bit forced, so that to a certain extent, what they really wanted was to confront the European Court of Justice, and for lack of a better opportunity, they used this case to finally do that openly. And there are some aspects that, in fact, seem to indicate that. One is what Franz says, the extent to which this doesn't really seem to meet the standard, the very high threshold that the Honeywell decision had established for when the German Constitutional Court would intervene. Other ones are symbolic. I mean, just before we initiated the broadcasting, I was telling that very few people has noted that that they chose the 5th of May, that is the anniversary, to to pronounce the judgment, that is the anniversary of the day that the coalition forces, the Allied forces, started to leave Germany after the Second World War. That was the date that the General Treaty entered into force, and therefore that the Allied occupation of Germany ended. And I wonder if that is a pure coincidence or not, that they chose that date. And to a certain extent, they might have wanted to use this case to really engage finally frontally to the European Court of Justice, also because it was the last opportunity for the current president of the court and the judge rapporteur, that are both living and that had very strong positions in that regard. But they may have forced it too much. As Deirdre was said, even if we've had two precedents of national constitutional Supreme Courts that have somehow challenged, never in those two instances they went as far, both in terms of language and both in terms of declaring a EU act itself ultra vires. And this, to a certain extent, undermines their own reasoning, because one of the paradoxical aspects of the proportionality judgment that they do is that the effects that they note are effects that dominate the debate on the ECB policy in Germany. But there's no mention, for example, of the effects that are positive in other member states. And this highlights the extent to which it's complicated for a national constitutional court to assess the proportionality of a EU act, because by definition, national judicial proceedings only have participating in those proceedings national interests. The litigants that went before the German Constitutional Court frame their interests by, naturally they are German interests. Those that stand to benefit in Greece or Spain or Italy or Portugal or France or whatever, they had no saying, and therefore the German Constitutional Court did not took into account those kinds of effects, for example, in its proportionality assessment. So that kind of seems to undermine. To which extent do you think that was taken into account? To which extent do you think the politics, including the judicial politics, the relationship with ECJ, the fact that the ECJ probably should have engaged more in its own vice judgment with what the German Constitutional Court, and somehow there's some blame to be shared on the part of the ECJ. Also, I might have played a role in provoking further the German Constitutional Court. How do you explain the decision in this context?
So thank you very much, Miguel, for the invitation to this debate. Well, for me, the decision of the German court is in really a transgression of competences, of judicial competences. So here I would agree with Franz Meyer. Constitutional courts always deal with political questions, and constitutional courts, their decisions have political impact, of course. But the way they are deciding, this should be on the basis of legal rules and of legal methodology. And for me, an indicator that this is a transgression of competences, you can see that the methodology is so weak, that there is a flawed methodology. And this is an indicator that they had sort of certain political intention. So there has been already talk that, for example, the way they use the principle of proportionality, this is a very German way using it. And usually you use it when it's about basic rights. But here it's a question about competences of the European Central Bank. So I think with also if you see this language, which is really like in a battle against the European Court of Justice, and that what the European Court of Justice said is really beyond the competences. And then in the end, you see a decision which is very near. The result is not so much, you know, to bring an explanation for the European Central Bank within 3 months, they can easily do. So I think here we have an indicator that what has happened here is really exceeding judicial competence, what they are here doing. And when you read the decision, what could be the political intention? You can see that this is really deeply anti-European. And of course, in politics, this can be your opinion. Of course, you can have the view that there should be no fiscal politics, there should be no economic politics, and so on. But here you could have cite many passages of the decision where you can see that they really have a political message in this decision, and I think they have this political message in all their decisions, all with Maastricht Treaty, with the Lisbon Treaty, then also with the OMT, and now finally they wanted really to bring it to the open. And they had really bad luck to seize a case where it really does not work. I think this makes it very open, perhaps with something which would have been more to the core. They could have found an argument, but taking it with this example, this is really, I think, was a mistake. So I would agree with the dissenting opinion of the former constitutional judge Margarete Löbe-Wolf with the OTM case. I think the same is true, all her arguments for this case as well. And also the European context, I think it's very clear that the German court has a very inward-looking way at these questions. They don't, what you said, realize that probably in other European member states, the proportionality analysis is dealt in a different way. And in this case, it makes sense not to have all the stages and the final stage as well, but just to see, does the decision of the European Central Bank, is this more or less monetary politics or too much economic politics? So I think here you can see it's a very German way of looking at it, and whom to blame as a political scientist, I would never only blame the court, but I think here we can also see the flaws of European politics, because they always hesitated to discuss this in public, what's going on with European Eurozone, with the Eurozone crisis politics, how to manage it. They have many changes in European politics, but they never really discussed it. And I think here, as they had sort of, didn't really make this on a treaty-based thing, their new policies, they should need a really democratic fiscal economic policy in the European Union. They never did it, they always hesitated, and now the Constitutional Court can step in this vacuum of power, and I think in this case they have shown that they have it's a court with an agenda in European politics against the European Union, and insofar I think there in the second round we will discuss about it. I think now there is the time where we have to discuss on the judicial level, but also on the political level, what's going on here.
Thank you, Christine. So let me give you the floor now to Jean. Jean, in light of what Christine said, I'm almost tempted to jump a little bit what we said and ask you the extent to which you expect that this decision might actually lead the other, let's call it, political actors in this context too, of the European Union to take bolder steps in terms of genuine fiscal union, for example, and the recent agreement between France and Germany may be a sign of that. But I wanted, before you can also address that, but I wanted you to also address the question of the extent, as an economist, how do you see a court trying to balance and determine whether something is monetary policy or economic policy? Is that feasible at all? And now from the perspective of a European Central Bank, does this kind of scrutiny of the decisions of a central bank is liable or not to affect its independence and affect the effectiveness and the credibility of the role that it needs to perform?
Okay. Let me start from the basis and discuss, as an economist, because I want to add this perspective, and then go and address what you're asking and say something positive at the end about the German Constitutional Court, because that's missing in the debate so far. I'll start with the easy part, which is monetary financing, which is an old debate. And so here, the court, the Karlsruhe court, does not do much, but there's a twist in what it is doing, and it's a significant twist. The twist is that it takes a list of indicative criteria given by the ECJ for deciding that the PSPP was not an infringement of the no monetary financing requirement, and it is turning this list of criteria into imperative criteria, which means, for example, it says the volume of purchases has to be limited from the outset. Well, it is not, and it shouldn't be. I mean, it would be, you know, to start telling markets that the volume of purchases is going to be limited from the outset is a contrary of what you should be doing in this kind of situation. And it says a purchase limit of 33% per issuance has to be observed. I mean, it may not be. And actually, the ECB has indicated explicitly that it wants to consider benchmark as sort of long-term benchmark. The same is true as regard the capital key and the composition of purchases. So they're turning what is considered a sort of medium-term benchmark into an imperative criterion for assessing the policy as it is. So what I'm afraid of is that when the Bundesbank goes to the Karlsruhe court to explain that, no, what the ECB is doing is perfectly legal, it will actually endorse this reading by Karlsruhe of the criteria for no monetary financing. And then it will represent a constraint on ECB policy down the road. So I think that's a significant risk in terms of policy. Although, you know, they are basically giving apparently the blessing to the policy of the ECB in this regard. In fact, this may be you know, important in terms of the implications. Now, let's go back to this question of the proportionality, which I read, you know, I'm a simple-minded, so I'm reading it as meaning, is there mission creep? I mean, is the ECB going beyond its mandate and expanding its competence by its own authority? Now, what I'm struck by is that the basis for the Maastricht Treaty is monetary dominance, meaning the ECB has a monetary mandate, and that has overriding in terms of the priority with respect to other objectives. So for a long time, it was a discussion about inflation versus growth and unemployment. And the ECB was actually required to give priority to price stability as opposed to other variables. Nobody would have said that the ECB has failed to consider the implication of its policy for you know, growth. It was this lexicographic approach. You know, you do whatever it takes to reach your price stability objective, and it may imply significant unemployment. It may have adverse consequences of some member states, but that's your mandate, and you have to do it. And then, if this goal is met, then you can consider other objectives. That's the way, since the start, we interpreted the Maastricht Treaty. Now, what the German Constitutional Court is doing is that it says that losses for private savings in Germany, implicitly, I mean, just look at the list of people who testified for this case. It's extraordinary. They're all German, and half of them represent a special interest in Germany. So that was really the case for the Savings Banks Association, really, that they're making. So that they have to, the ECB should consider that, but it shouldn't consider the implication for other aspects of economic policies in other countries. So that's really extraordinary to require that. Now, where do I think that there is still something, you know, we have to discuss seriously? I think the distinction between monetary and economic policy is not something you can easily put aside. The basic philosophy of the court is that Parliament has rights and cannot be deprived from those rights. So Parliament has rights for whatever is fiscal, for whatever has a distributional dimension. And this is a constitutional requirement, and an independent agency with a different mandate for monetary mandate cannot take over responsibility for distributional policies from Parliament. Now, we all know that monetary policy has distributional consequences. I mean, obviously, when you increase interest rate or lower interest rate, this has distributional consequences. The tradition was to say, over the cycle, they're balanced. So, there is no difficulty with monetary policy having distributional consequences as long as it is balanced over the cycle. And as long as the government has, and Parliament has, other means to correct those defects. Now, with the quantitative easing, we entered a different world where there's no cycle anymore, really. We're speaking of very long-term effect. And so the whole discussion was whether Parliament and government had other means to correct for some of the distribution consequences of those policies. And but this is not a discussion you can put aside. Now, what the Constitutional Court, in fact, is saying is that by controlling, and there's a sentence saying that, by controlling spreads, the ECB is in effect having a distribution effect among member states that does not correspond really to its mandate. And I think that opens, and that's, going back to the question, Ray, that opens a very important discussion on to what extent can heads of states and government subcontract to an agency whose mandate is relatively narrow the responsibility for solidarity, for mutualizing some risks, for which they don't take or they didn't take explicit responsibility. And that brings us back to the declaration by Macron and Merkel, where there was this significant, extraordinary change of position by the Chancellor, saying we need transfers, we need common borrowing, which means taking explicit responsibility for a fiscal policy at EU level in response to this crisis, and ending, in effect, the stance that there are things we've got to do. They're relatively dirty. We don't want to take responsibility for them in front of public opinion. Let's have them done by the ECB, which was a very clear temptation by many heads of state and government. So I think the message in what the court is saying has to be heard. That doesn't require to sort of accept what they're saying and what is deeply unacceptable on substance from an economic as well as from a legal point of view. But I think the big question behind is how we define what belongs to political decision, what belongs to parliamentary decision, and what belongs to the decision by an independent agency with a narrow mandate.
Thank you very much, Jan. So, Franz, I have two questions, and that relate to some questions that have been put here also by some people in the audience. Jonas is collecting some of the questions, is giving some of them to me already. But a first question has to do with this that Jan was saying, that in fact, it does seem even that the German position and now together in this proposal with France might be seen as a change of approach that could be in part a consequence of the decision of the German Constitutional Court. So if you want, I myself wrote an op-ed yesterday saying that this Constitutional Court decision might intentionally or not end up leading to more integration instead of less integration. That being so, to which extent do you think that that approach that will lead to a more genuine European fiscal policy, and under which conditions will be compatible with the case law of the court that is not limited to the ECB policy? Because as you said, it imposes limits that are moreover limits that it sees as material limits, so that they're not even subject to constitutional amendment, on the degree to which we can have a transfer union within the European Union, on the degree to which we can have mutualization of risks. It seems to me that if this mutualization takes place through the EU budget and through EU-owned resources, the risk is lower of it entering into conflict with the constitutional reading that the German Constitutional Court has done, and in that instance, not only in this decision, but in past decisions. So that's the first question to you. The second question is, if you could develop, also in light of one question that was posed by Jan Forrester, what are the exact consequences of the decision, and to do that in light of the fact that you expressed a preference, contrary to Deirdre, for an infringement to be started against Germany on the basis of this decision. And my question to you is, at this point, we don't actually have an actual infringement, because we will only have such an infringement if the Bundesbank would stop participating in the ECB program. And so far as not, because the court basically gives it 3 months for them to obtain a new decision of the ECB that basically will explain and justify the proportionality. So how likely do you think that this may happen? How likely do you think that it is actually necessary for the Bundesbank to demand a new decision of the ECB, or if it might be enough if the ECB provides a renewed justification, either in answering requests for information from the German Bundesbank or even questions from members of the European Parliament?
Okay, so that's a lot of stuff again. Well, just quite briefly on the first point, whether this new Franco-German initiative is related, to what extent it's related to what is going on. On a very formal level, it's unrelated. I mean, on the one hand, you have to see that this decision was basically ready by the end of last year, at the beginning of the year. That's part of their problem. It's really bad timing. You know, they saw just really a very, clear slate. They thought that's a good moment to just make a statement and to send a couple of messages. And they didn't see the COVID crisis coming, obviously. And now they are really in trouble because with the COVID crisis, everything has changed. But that also means that I believe that the Franco-German initiative they have prepared for that for some time. And now there's this coincidence that this is about aspects of the further development of the Eurozone and of European integration that seem to be related. But on a very practical level, this is, I believe, unrelated. What is true, though, is the question of how do we bring this issue back to politics, and this may be leading to what could be, the exact consequences and what will happen next. Again, I believe that this is what's going on here is ultimately it's political questions on many accounts. I was representing German Parliament in the proceedings before the court in 2012 in the very first Euro case, the EFSF case. And I pleaded at the time, I said, this is a classical case, judicial self-restraint, don't get into this. The economists don't agree. I mean, you have 2 economists and 3 opinions on this. So how do you 8 people on the bench? How do you lawyers think that you know where to go? And it just seems utterly absurd to me. But they didn't follow that. They don't really like this judicial self-restraint thing actually at the German Constitutional Court, and it's pretty hard to induce it. But again, it's the question, how do you bring back politics? And this will be a topic. There's a hearing next Monday, 3:30 afternoon at the German Parliament, will be broadcast because we're in the Zoom mode, the Parliament as well, and there will be a couple of experts. I'll be there as well, and we'll try to give answers to that, what to do next. Because obviously this is a situation where you're really in danger of damaging all kinds of players. I mean, the ECJ, the German Constitutional Court, the European Legal Order, the Bundesbank, the ECB, we need to find a face-saving solution that basically, makes sure that all these players remain more or less undamaged, and that will be really hard. So for the treaty infringement...
Because I have questions from Carlos Closa.
Yeah,
and that is asking whether you think that the German Constitutional Court will actually not see its authority vis-a-vis other constitutional courts undermined by this decision. And that fits another question by the director of our school now, Alex Stubb, that is also listening, that basically is asking all of you if you don't think that in the end one can reach the conclusion that the German Constitutional Court has shot itself in the foot. So these two questions are somehow related. Do you think that ultimately that will be the reading of the?
I'm not going to make any predictions on what is going to happen. Again, all I'm saying is that they didn't anticipate the current situation. I think they were pretty surprised. They anticipated some kind of, critique, but the fact that they went out to give interviews and all that has happened before, but not to that extent. The treaty infringement procedure, just to get back to your point as well that you made, Miguel, I do see a treaty infringement here. I mean, they just basically said we will not respect the preliminary reference ruling of the ECJ, and they called upon German institutions to, somehow interfere with the ECB, and I would consider that at least a starting point for an infringement procedure. But again, the question is how to bring that back to politics. There's one obvious way out: just do away with the independence of the ECB. I mean, that would solve many problems because their core point is democracy, and in a way, the way all this has unfolded over the years was that when it was all about the euro crisis and you had ESM and all that, their solution was always turn to the German parliament. If German parliament gives the green light, then it's okay. Obviously, that doesn't really work when the ECB is in the driver's seat, because the German parliament and the ECB are unrelated. The ECB is independent. But in a way, that would solve the issue if you would take away the independence from the ECB and expose it to parliamentary scrutiny. And there again, we have a German court case law which clearly points to national courts and not to the European Parliament. They are on record with a statement that they don't really think that the European Parliament is a legitimate democratic institution. So that could be a way out. But all other way outs are extremely hard to argue because you have this link with the eternity clause of the German constitution. The way they link this to a core democratic principle that can't even be modified by supermajorities in the German polity, there's just not much you seem to be able to do. And that's the hard question. How do we overcome this? And the technical answer is we would need a new constitution, but that obviously we didn't even get a new constitution after reunification. So we will not get a new constitution in that context. That's pretty clear. The path dependency of the case law is extremely strong. So even when you replace judges, and you said it, Miguel, one of the judges just left the court, but the judge rapporteur will be there another 2.5 years. He's not leaving. So you have another 2.5 years of cases like this. And just one final point on the consequences. The proportionality argument is extremely dangerous because the way they set this up, this may apply to all EU action. And just imagine a proportionality test exercised by basically any national court on anything that is related to competition, to state aid. I mean, then you can just wave the European legal order goodbye. If this is what could happen, that basically any national institution could question European action, any European actions on grounds of proportionality, because what they do here is not really jurisdiction on the outcome. They just say you should have taken into consideration this or that, and they will always find something that was not taken into consideration, I'm pretty sure. And that's really the kind of the nuclear aspect of this case.
Thank you, Franz. Deirdre, I'll start with a question that comes from Joseph Weiler that is listening to us. And Joseph is also critical of this decision of the German Constitutional Court, but he reminds us that perhaps there is at the same time a problem with how the European Court of Justice has itself exercised the role of monitoring the borders of the powers of the European Union and of EU law. So the extent to which this should not make us think and reflect on what needs to be done at the EU level in order to reassure national constitutional courts at the German Constitutional Court that the Court of Justice of the European Union or the EU law itself has appropriate mechanisms to guarantee that the European Union does not exceed its competences. And he also asks the extent to which you or anyone else in the panel believe that there may be instances where a national Supreme Court or Constitutional Court may be entitled to disregard the decision of the Court of Justice of the European Union. So that's my first question to you. The second one is if you could develop, because you hinted at that in your first intervention, on why, contrary to France, you oppose the idea of an infringement to be started by the Commission. And link that to another questions that have been made, that is the question of the risk of spillover of this precedent for, in particular, constitutional courts from illiberal regimes, and everybody is thinking of regimes such as Poland and Hungary. If the Commission will not even at least threat the possibility, leave open the possibility of an infringement action, what could the Commission do if then Hungary and Poland, through their constitutional courts, take similar actions? Wouldn't that be a risk?
Sure, thanks, Miguel. Maybe I'll begin with the latter question. You know, and many people have pointed out in various commentaries, of course, this is a risk of the spillover to illiberal regimes, and you know, and it seemed almost that the Hungarian government had even immediately almost was going to use it. It now seems that it has pulled back from that and has agreed to do away with the transit camps, apparently only this morning. But anyway, that's just an incidental example. But I just think that, I think there's nothing wrong with it. I mean, the Commission has already threatened infringement proceedings and is investigating it. But I'm not sure that that is the right way to go already now. Of course, you know, infringement proceedings take a long time, and they involve lots of dialogue also with national authorities before they actually get to the court. But the court, who would, if they did get to the court, would be the Court of Justice itself. And I'm not sure that that is desirable. You know, and the Commission has been famously reluctant to have infringement proceedings, very difficult against a court judgment. But also, I think, you know, it may be less radical than it seems right now. I mean, yes, the court judgment has been very explicit and very rude and very, you know, almost laughable in certain respects. But now one has to see how it will be followed up also by the German government and the other actors. And they cannot, even from the authority of the German Constitutional Court, simply not apply European law in whatever they do as a response. So my sense is there will be some sort of outcome that, because after all, it's only the process. The court hasn't said that in substance there's a violation of proportionality, so they didn't have enough reasons or evidence in that regard. And perhaps that evidence will be forthcoming. I mean, and if it's not, and if the only way of getting it out is through the initiation of the early stages of an infringement, then perhaps. But I don't think one should immediately rush into that. That's my sense in that regard. And I understand that many people are actually calling for it. In terms of Professor Weiler's question, yes, I think, you know, there is examples, and also he has argued that for many years, of the court not necessarily being a very good policeman, as it were, in terms of the jurisdictional limits. And perhaps for the future, the time has come to think more about managing in a more pluralistic fashion, in fact, certain difficult jurisdictional questions that could come before a constellation that is more composite of the national and the European level. Of course, it's a matter of reality in terms of initiating and all of that. And the last thing I would like to say is that I mean, I see this also as an opportunity in a sense, and in that sense, I agree with some of the writings that in terms of increasing the accountability of the ECB. I mean, the ECB is supposed to be politically independent, but not legally independent. So this may be the moment that both the ECB itself engages more in terms of its reasoning and publicity and all of that. And the court itself in Luxembourg realizes that it has to, you know, go into it deeper in some way and not just very minimalistic scrutiny. So there might be a rethink of that out. And independence from political accountability doesn't rule out more legal accountability.
Deirdre, can I ask you, because some people have made that question, actually not Joseph himself, but I remember this proposal. Well, they didn't say that it is a proposal, but I think it's actually a proposal that was made initially by Joseph, if I remember well, by Joseph Weiler, of creating this kind of special court chamber that will bring together the presidents of national supreme or constitutional courts with the president of the European Court of Justice to decide on ultra vires cases. Do you think that will be a time to reassess and consider that possibility?
It may well be a time, and we're going to look, there will be future of Europe, you know, we're looking into, we'll be looking into various possibilities of what could happen. And I think this may well be a good time to do that. Also, given the nature of the kind of issues that are coming before the Court of Justice. I mean, they're very intricately tied in with national competences in a way that is perhaps different to what it was originally when the judicial system was set up. So there may be grounds for re-looking at that now to see what could happen in highly specific circumstances. So not on the interpretation of EU law, that has to be unequivocally the task of the Court of Justice, but on the ultra-virus issue.
Thank you. Christine, how do you think that will be the reaction of the German political institutions, first with respect to the specific consequences of the case? Do you think that the Bundesbank will require the ECB to actually issue a new decision, what will be very hard for the ECB to do without opening a very dangerous precedent? Or do you think they will be satisfied with simply getting additional information justifying the proportionality of the measure, even if that is not the specific requirement that the case imposes? And now, how will that be accepted in Germany itself? And second, do you think that politically what's happened, for example, on the meeting between Merkel and Macron and their decision, can be seen as Germany understanding in light of this decision too, that more needs to be done, but at the political level in the EU?
Well, with the consequences, Miguel, I think they will try from the Bundesbank to get just additional information and to have more reasoning for this program. And might be, I guess, that at the moment, you know, there are so many real problems on the table that they are really going, yes, to do this. And then the European Central Bank, I think, would not have a big problem to offer the information. They have all these documentations. So exactly if the constitutional courts would have looked for these documentation of reasons for the program in question, they would have found it. I think for the debate on the infringement, perhaps I think it would be an idea to open the procedure, but not going to the end with the European Court of Justice, but having it as a dialogue. And then during this dialogue, The proposal, what you just mentioned of Josef Weiler, that there would be a third chamber, and then this chamber would decide when there are conflicts between a national constitutional court and the European Court of Justice about ultra vires, they could decide on that. So imagine there would have been a second possibility for the German court to go back and say, well, we would have questions for that. Isn't this ultra vires? I think this proposal should be discussed. With the question, what about the initiative of Emmanuel Macron and Angela Merkel? Is this already an answer? I think in some way it is an answer, because you see now politics are doing something very different from what the German Constitutional Court is wanting. So you also can see that a constitutional court exceeding its competences loses in authority. So you could say, well, the Constitutional Court has decided this is against the competences of the European Central Bank. What is the European Central Bank doing? Having a new, on the 18th of March, a new decision, spending much more money for the COVID-19 thing, which is, if you take all the conditions in the decision, this program would be also had to be said, well, this is not in the competence of the European Central Bank. And we will have more constitutional complaints on that. So you see a parallel development. The court is losing in reality, in authority. We have a lot of debates, but these don't sort of impact the real politics. And also, this relates to what Jean has said, that there is a point that economic and fiscal policies on the European level, this should have a real legitimacy. And now what Macron and Merkel are doing with this program, well, so far it's a proposal, but wherever it goes, this will have to go back to the parliaments, and then there would be more of a democratic legitimacy. And I think even more, we have to take up this point and saying, well, we see politics did not do their housework. Now the court has exceeded competences, but we leave this aside. It's time now to take perhaps also the chance of this crisis and saying, well, you see, Merkel, she has always been against spending and sharing a risk on the European level. And now all of a sudden, she is doing this. And this is absolutely different from what in Karlsruhe at the Constitutional Court has happened. So I think this is an interesting development. It's also something which the judge, Margarete Lübbe-Wolf, has said in her dissenting opinion. She said, when a court does not take in account what the impact for the real politics are, they lose in authority, and they don't have influence anymore. And I also think this is something which is happening here, and opening an infringement procedure would perhaps be a chance to get more into dialogue and to open up also a little bit the eyes of the judges, what is going wrong on the side of the judges, being sort of more in a direction of European things. You cannot always decide this on a national level, what is going on in the European Union. And this is what they really did also with the methodology. It's interesting how they have the idea that there's only one way to have a proportionality analysis, which is more, well, it's in many places it's used, but it's very German, and saying this for all the other countries. So I think an infringement procedure as a chance for a dialogue, and perhaps also discussing this third chamber of the European Court of Justice. This would be perhaps a good idea.
Jean, I know that you have two questions for Franz, so I'll give you the opportunity to do that, but I also want to ask you if you could do what the lawyers have refused to do, that is to try to predict what's going to happen, particularly at a broader level in terms of in the euro area and with respect to this crisis. Lawyers have great resistance to make prediction. On the contrary, economists are famous for making predictions, not necessarily getting them right, but at least for doing them. So I wanted to ask you if you could take that role.
Okay. Now let me start with my two questions. One is legal and one is more sort of political, philosophical. The legal question is, can the Constitutional Court instruct the Bundesbank to behave in a certain way, legally? I mean, the Bundesbank is independent from government, but it's part of a constitutional order. And so as the Constitutional Court, I mean, says the truth on the constitutional order, how far can it go in restraining what the Bundesbank is allowed to do?
You want Franz to answer now, or maybe at the end of your?
Okay, but I have a second question to him.
Okay, go ahead.
Well, perhaps, yeah, I'll give my two questions if you can answer, and then we go back. My second question is sort of what's going on. You know, we're not speaking of one particular judge. We're speaking of an institution, we're speaking of a majority of 7-1, and we're speaking of a series of cases in which this philosophy has been asserted by the court. So it reminds me a bit to what we're seeing in the US at the Supreme Court, where you know, you have philosophical battles going on. The partisan of the original intent, for example, as opposed to those who think that the mandate of the Supreme Court is to you know, go along what's going on within society. Are we seeing some sort of politicization in the same way? I mean, I'm not criticizing politicization per se. I mean, you know, a philosophy that is being asserted by legal community or by a significant part of the legal community, and that would tell us that for, you know, a long time to come, we're going to be facing this kind of philosophical battle with a particular aspect that in Europe it has a strongly national dimension. I mean, it's not a federal discussion. It's a discussion that involves a particular member state and the legal, the highest court of a particular member state. If it were so, I mean, this would have profound consequences because also other courts would inevitably step in, and this, you know, battle on what the EU is about and what the nature of the legal order of the EU would probably last for long until it is settled.
Franz, do you want to answer that before giving?
Sure. Well, the first question, can the German Constitutional Court instruct the Bundesbank to behave in a certain way legally after the 3 months? And it's true that if you look at the decision and recital 235 of the decision, it's actually what they say. They don't address the ECB. They just say, well, let's see what happens, whether the ECB produces some kind of you know, evidence that they did a proportionality test. If that does not happen, after 3 months, the Bundesbank is legally prohibited to participate because that's their ultra vires argument. Then we would assume that the ECB is exercising powers that were never transferred to the ECB. And if that happens, any German institution is prohibited to obey to this European legal pseudo act. Now, if the Bundesbank would just not react to that, they do have a tool, and then they can activate that even without a request from the plaintiffs to execute their decisions. It's in for the, if you really want to become a connoisseur of this, it's in section 35 of the Bundesverfassungsgerichtsgesetz. Now, the tricky thing is that they can only execute things that are in the dispositive part of the ruling. And now the dispositive part, this 5 or 6 bullet points after in the name of the people, doesn't mention the Bundesbank. So here you have already a point, one of the inconsistencies in the decision, which may be related to different fractions, which will lead to the second question. So what I'm saying is, it's not really clear if they could actually really issue an executive order, so to speak, in order to execute this part of the decision. If they did, the Bundesbank would find itself exposed to the two loyalties it has, because it is a German institution, but it's also part of the European system of central banks, benefiting from all the EU rules that shield the SCB from interference. Now, they could just say, well, actually, here we're acting as a European institution, go away, German Constitutional Court. if they decided to follow the German Constitutional Court, the ECB could again order the Bundesbank to follow its obligations under EU law. And if the Bundesbank wouldn't follow, this would go to the court, to the European Court of Justice. So either way, you would end up again in the courts. But just to make that point very clearly, I'm pretty sure that this scenario will be avoided at all costs. Clearly, it would be convenient for the parliament, for German parliament, for German government, just to say, well, let's see what happens. Let the central banks sort it out. And then it would ultimately be basically the Bundesbank who would have to decide either side or the other. And I'm really confident they will avoid to put the Bundesbank into this really untenable situation at all costs. So that's for the first question.
That would bring to the scenario I mentioned earlier, that the Bundesbank will try to find some sort of middle way.
Well, one answer to that, what could happen, because Miguel, you wanted us to be kind of making predictions. I can give you a prediction, no problem. No problem. I have a lot of creative fantasy out here. No, one thing that may happen is that the ECB, I mean, you know, the absurd thing here is that the German Constitutional Court seriously kind of suggests that the ECB makes such a program without having reflected on the consequences. I mean, of course they did reflect on the consequences. This must be on file. That's no problem at all. And again, the German constitutional jurisdiction is not about the outcome of the balancing. They only want to see, have you seen all the impact? And the ECB could easily kind of issue that. And why don't they go to, say, the committee of the European Parliament they talk to all the time? They could go to the European Parliament, say, well, there's a debate going on, and implicitly saying we're not following the orders of the German Constitutional Court, but as this is some kind of public concern, our transparency initiative, etc., we feel that it's a good idea to go to the European Parliament, which is our interlocutor, to show what we have made in terms of assessment of impacts and all that. And then the German Constitutional Court could say, well,
any member of the European Parliament can address questions to the ECB, and the ECB could, in the context of answering a question addressed by a member of the European Parliament, provide that explanation.
Right.
But they did it already. There was an extensive discussion on QE and inequality. There was a series of speeches by Draghi and other board members, and I'm sure, I didn't check, but I'm sure there was a debate in one of the hearings before the European Parliament. So,
but again, this is not really on substance. In terms of substance, I don't really see a problem with, the ECB not reflecting on its programs. This is just the matter now is how do we get a face-saving solution, saving faces for most of the players involved. And that could be an option. The ECB is just kind of reiterating what it also, they even do it in the Bundestag actually, just the Bundestag cannot officially refer to that because all this is informal contacts. Of course, the ECB president has been talking to members of parliament, has been to committees, but that's not something that is really, in the current situation, I believe that talking to the European Parliament would be a solution. The German Parliament could refer to that and say, hey, look, the ECB has reiterated its motivations. We are convinced, and that's enough for us. The problem that you have is that if you look at the wording of the decisions, they request an ECB decision. But there I would argue, well, let's just not, take that for, not every half sentence of this decision must be executed. If they really seriously want to bring, the ECB to take that decision, they can't do it. I mean, I would take that risk. And it's the only way out that I see. The ECB must not directly obey to the German Constitutional Court and say, the German Constitutional Court said we need a decision, here we go, we take the decision. Because next, the Italian Parliament may try, the Italian Constitutional Court, the Portuguese Constitutional Court, the Portuguese Parliament. I mean, that is something that will just even more open the Pandora's box, which has already been unlocked. And so again, my idea would be that at some point you just have to see what is at stake and to find a creative solution. Briefly on your second question, if I may. I know the time is running, but
yes,
about the majority. It's about the majorities in this second Senate and whether there's this kind of philosophical battle. I agree. I believe there is a philosophical battle, and it's to some extent, it's the arbitrary composition of the bench that plays here. I mean, if there had been the three judges that were dissenting judges 1974 in the Solange 1 decision, which was extremely pro-European and in the same time upholding the German constitution, if you had people like that in the majority, things would have turned out completely differently. And if I look at the more recent case law, you know, I represented the German government in the Unified Patent Court case. That was decided a couple of weeks ago. We lost that case, but it was really tight. It was a 5-3 majority that basically formed the majority. And I was wondering, where did the three minority judges go in that case? And one way to look at it is that they are still there, but they are in the inconsistencies of the majority. You know, maybe there was some kind of negotiation going on inside the court. They had a slim majority, which would have been much more terrible. And the three judges that were beginning to form this kind of it's probably oversimplified, but arguably they are more pro-European than the others. They kind of saw that they needed to avoid that this becomes utterly catastrophic. So part of them joined the majority, and there's still one dissenting without writing a dissenting opinion. So there's one voice, one judge against. And if that is true, things may change, because one of the judges that was pretty sure in the majority, the president, Voskuhle, just left the court. Technically, he's still there, but the succession has just been decided last Friday. And so I think that the 5-3 majority is gone. So it may be a 4-4, and that could help to avoid, the worst. But still, you're totally right that this is kind of a philosophical debate which is reminiscent of what is going on in the US Supreme Court. Having said that, I don't see that this is a new thing. That's been going on for the last 20 years or so, and it has not really spilled over into the other high and supreme constitutional courts. So that's probably a sign that will indicate that that's not something that will happen now in the near future. And we will have this kind of debate and interference from all kinds of constitutional courts from all over Europe. I hope so.
Okay, Franz. We have to, just before giving each one of you 1 minute, 2 minutes to conclude, I want to give Jonas the possibility, because there were many other questions that we were not able to put on to the panel, but I want to give Jonas the possibility to bring at least 2 of those questions. You choose which ones, and to the panel members that you may or not address in your final statement. Jonas.
Yes, thank you very much. I would like to start by thanking the audience for the vivid engagement and plenty of questions that have been submitted throughout the debate, but also before the debate had even started, and apologies that we had limited time to take up only a few of them. 2 I would like to add to the discussion now. Sébastien Platon asks, if there was an infringement procedure, wouldn't it have the adverse effect of forcing Germany to defend the GCC's ruling, because they would have no other choice, even though it seems that the German government is not very happy about it? And Thomas Stadelmann asks, do you think in general that there could be a situation when a national highest court could be right in finding that the ECJ was deciding ultra vires, or has this legally to be excluded from the system?
Thank you, Jonas. Franz, we start with you and then we'll conclude with Jean.
Just briefly on these 2 questions. I mean, obviously for the treaty infringement procedure, it would be a tricky situation for the German government what to do. Maybe they could hire an external counsel. So for example, Andreas Voskuhle is available right now. He could try to argue. And could a national court, could the national court be right? Of course that could happen. Of course the European level could infringe their powers. But I believe that the Honeywell decision, they led a pretty clever path. They said, well, there could be, and I think that was much more stabilizing than what had happened. My final word would be just on a couple of brief points. The first one, there's a very simple way to tell the story that it's all about judicial egos. The German Constitutional Court made its very first reference in the OMT case. They suggested a solution in a way that was not questions, but rather a diktat. The ECJ didn't like that. the German Constitutional Court was disappointed, you know, some kind of disappointed laugh, and they were saying, we try it again, and if they don't obey us this time, there will be, you know, punishment. And so that's probably as simple as that. There's a lot of psychology here. And there's also a role maybe for the ECJ here. Maybe the ECJ should have been more, you know, gentile with the German Constitutional Court. So there's maybe two sides to that. But there I would really ask them to behave like grown-ups. It's just too important, what the things that are at stake here. In a more general sense, it may be, as one colleague of us said, about the constructive ambiguity of the European project, in the sense that what they do here, the German judges, they try to bend this kind of ambiguity that's been around all these years towards their side. They try to decide it's not a federal state, it's not a federal system, we have the final say. And I think that's the error, because the ambiguity, that was helpful all along. We tried to conceptualize that as constitutional legal pluralism and all that. And now, of course, it belongs to the EU side not to make the same mistake from their side, trying to bend it towards their side. So we have to get back into this kind of ambiguity, which was pretty stable. And the last point, I believe it was really a missed opportunity. The German Constitutional Court could have made all these points, been very critical of the central bank, of the way the ECJ scrutinizes the central bank. And if then they would have said, but because it's a community of law, we still follow the decision of the European Court of Justice, you know, pointing to Poland and Hungary and all the others who have issues with EU law and the European community of law, that would have been much more effective than what they are doing right now. And again, it was said by someone right now on the panel, ultimately it may also damage and diminish their own role. So again, thank you for having me. Thanks.
Thanks, Franz. Deirdre.
Thank you. Well, just to add to a different, a broader perspective, I think that, I mean, in a sense, it does put, again, the spotlight on the European Central Bank and its accountability and even its transparency. And I think that this is an opportunity for that to be re-looked at and also legally, and an opportunity for, but also for itself to proactively, which it's already engaged in, but it could engage even more in this. I think it sees the need to take public stances on things. The fact, you know, one of the most striking things also here is so many actors responded publicly as institutions to the judgment of the German Constitutional Court. So I think the realization that the environment has also changed will come about as a result of this. The European, and the same in a sense goes for the European Court of Justice. I mean, it also, as you all know, issued a communication almost immediately after the judgment, which is quite remarkable. But also, the President, for example, gave an extensive interview in one of the Dutch papers. He may have done it in other papers as well, talking around the issues, but very much, you know, putting down very clear markers, as many of the judges have done also in Germany. So my sense is that there will be more of an understanding of the environment that they are currently operating also by the court, and that it also can increase its own transparency and improve the quality of the reasoning that it gives. And finally, just to follow up on what Franz was saying, I mean, my sense is that there is no violation now, even though, of course, the German Constitutional Court has said that the court's judgment was ultra-virus for various reasons, including methodological. But in terms of the executive part of the judgment, that is directed to German public authorities, and they have to respond to that. I don't see how they can respond to that without respecting EU law, you know, because they are public authorities who are bound by EU law as well as national constitutional law. I'd leave it at that. Thank you.
Thank you, Deirdre. Christine.
Well, I think the overall impact of the judgment is that really the judges have not taken into account the actual situation at the moment in the European Union. Of course, one can say these are judges, they don't take apart what is going on, but I think if you look about what the subject of this decision is, it was not such a structural decision to risk now at the moment that so many national constitutional courts now can refer to what has happened here, and this can give conflicts. So as we have already discussed, that it will be very difficult for the German central bank to make any prescriptions for the European central bank, and the German central bank is in a very difficult situation. I think that really the procedure of an infringement should go on, because this also brings more transparency to the whole situation, and perhaps they will have a solution. I think in the long-term impact, what we really see that somehow a constitutional court in this case develops like a repair shop. You know, things that are not done in politics, and then sort of they try to repair. So this idea would be something we also have to think of. So now the flaw is really on politics. With your question, is there any idea, would it be possible anyway that one can say, well, in this case, the European Court of Justice is not supreme of the interpretation of European law? There might be, you know, topics one can say, well, the national constitutional courts also have still a competence in really central aspects. This must be really the order of competences in the European Union. It cannot be, you know, a program of the European Central Bank. This is really, you can see it also with the, you know, seeing the language and the arguments of the judgment, and then seeing the small result coming out. So I think that there must be the possibility. There are also other constitutional courts in other member states who would say we don't give up totally our competence at some points to say, well, this is now not okay with our national constitution, but these must be very, very rare cases, and then they have to be discussed in dialogue with the European Court of Justice. My impression is that the German court really has lost some of its authority by this judgment. You can also see it by the real, what Franz already mentioned, with this real media campaign, that they realize what they have done. And also, you know, when a judgment of a court can only say practically in the end, well, the government of Germany and the parliament of Germany, they should influence the German central bank. What the only thing they can do to discuss, to have some more debates in the parliament. So this goes really back to what Gertrude Lübbe-Wolf has said in the OTM case, that she said, well, if they have then a judgment just saying not concrete things to be done, but just saying, well, somehow you have to influence, you can make a parliamentary debate, so what? So the effect is that though they misuse their power, in effect, they have lost in power.
Thank you, Christine. Jean, the last word is yours.
Okay, you asked me to give forecasts, right? Mm-hmm. So legally, I would say the problem won't go away. The Pandora's box is open. It's going to resonate with the political climate we're having in Europe. So it's going to, you know, I'm not predicting a disaster, but I'm predicting a sort of ongoing difficult discussion involving other constitutional courts or judicial instances. Second, on the monetary front, I think that there will be a solution in the short term. The Bundesbank will give explanation. The German Constitutional Court won't act on the basis of this explanation, but then there will be another case with the PEP, which will be inevitably brought to the German Constitutional Court, and the jurisprudence will be used to assess the PEP. And so anticipating that the ECB will find itself more constraints in the range of things it can do. So it's sort of a news. So it will limit the ability to act of the ECB. The bazooka has got smaller as a consequence of this rule. Now, politically, I think it adds pressure to on the heads of state and government to take decisions, to, as I said before, not to subcontract decisions that belong to them to the ECB. And I think it's one of the factors. We shouldn't overestimate it, but certainly in a way, it's a sort of blessing in disguise that it pushes heads of state and government towards taking their own responsibility in responding to this crisis.
Thank you very much, Jan. I think it was a perfect way to conclude our webinar. Thank you to the four of you for participating, and thank you to everybody that has been following us and participating and engaging through many questions. See you next time.
Thank you.
Thank you.
Bye.
Bye-bye.
Thank you.
Bye-bye.
Bye.
Thank you very much.